Good afternoon. It's March the 28th. We are here for what was to be set to be a voting session on Senate Bill 275. But as I've explained, and I'll explain once again, this is not going to be a voting session. This is going to be a listening session, a chance for my colleagues to consume and understand what this bill as amended does. So that's where we're at today. We'll be talking and voting this bill out tomorrow. I know we have Senate bill hearings. Those may be continued to another day because we do have two sessions tomorrow. We have a morning session and an afternoon session. So there's a good chance we will be continuing our hearing so we can get through this because I believe it's going to be a heavy lift. Erica, let me know when you're ready to go.
I'm ready, sir.
Go ahead.
All right, good afternoon, everyone. You all should have received the reprint that was sent earlier today to your emails. And so I'm just going to get started. We're going to go page by page over the reprint. And, we'll stop along the way for questions. So the first couple of pages are just technical. The first page is just the purpose paragraph. Page 2 is where the definition section started. Over in the Senate, they added a definition for deployment. The Senate added the definition for deployment to allow the Title 10 and Title 32 orders for National Guardsmen to be included. There's also, so the employer is now limited to people with 15 or less employees. And the Senate removed the reference to different business types that were exempt and removed the next of kin definition because it was already in FMLA. So they didn't think it was necessary. Okay, on to section 8.3102, which starts on page 6. This section is just information related to a claim cannot be disclosed to certain individuals in the course of business, and it preempts local jurisdictions from passing new laws related to paid family medical leave that would impact private employers.
Mr. Chair, can I ask where she is exactly because I'm not seeing it?
Should be on page 6
of the amended bill.
Yes, the reprint.
Okay.
Last one sent out. Sent out at 9:49 a.m. on the 26th.
No, it's what Kayla sent earlier today.
Wait, there's a
But
new
the data, no, it's the same thing. It's the same
Okay.
thing. That's just when it was printed. So you should have gotten it from Kayla.
Yeah, I got it. I got it here. Okay. So
Okay.
you were on page 6, you said?
Yes. Page 6 is at the bottom of it is the part where it preempts local jurisdictions from passing laws that would establish their own paid family medical leave programs
Okay.
that would impact the private employers. All right, is that good?
Yes, thank you.
Okay. So now we're on to page 7. Section 8.3-201. This section defines self-employed and authorizes self-employed individuals to participate in the program for the initial 3-year period. Then they can renew on a yearly basis. So the next section is 8.3-202, which starts on the bottom of page 7, but is really on the top of page 8. And this section just says employers are still required to comply with CBAs and collective bargaining agreements and or current employer policies that allow employees to take longer leave than what's allowed under this act. The next section is 8.3-203.
Hey, Chairman, I got a question.
Go ahead.
On that section we just discussed with the collective bargaining agreements. So if you've got a policy in place and it's a leave policy, right? Collective bargaining. And you say you need maternity leave or paternity leave, would you be able to apply for benefits under this program and also participate in your benefits under your collective bargaining agreement? Or does that mean that the collective bargaining agreement supersedes this program?
You would be able to participate in both. And actually, Delegate, we're going to that will come up later in the bill as well.
Thanks.
Are there any other questions on that section before I go to 8.3-203? Okay, So 8.3-203, also on page 8, employers are still required to comply with the collective bargaining agreements. And the policies do not diminish the employee's rights under the act, and the employee cannot waive the rights under this act. So the next section is 8.3-301, also on page 8. And that section basically just establishes the program in the Department of Labor. The next section, 8.3-302, states the purpose of the program is to provide temporary benefits for leave taken for the specified reasons, which include caring for a child after the first year of birth or the child being placed with you through foster care or adoption or kinship care, to care for a family member with a serious health condition, one's own serious health condition, to care for a service member that is the next of kin, or a qualifying exigency because of a service member's deployment. The next section is 8.3-401 on page 9. And that section just says that the Secretary of the Department of Labor has to administer it. And the next section, 8.3-402, authorizes the Secretary to delegate to an employee of the department any power of duty that's reasonable and proper for the administration of the title. The next section, 8.3-403 on page 9. The first of section A is a suggested amendment from the committee and says the Secretary, in consultation with the Department of Budget and Management, the National Federation of Independent Business, the Maryland Chamber of Commerce, and a representative of a private sector labor union, they shall work together to establish various procedures and regulations. The regulations must be consistent with FMLA and other state law, requires a certification for a claim, even for intermittent leave, and lays out what should be included in the certification. It also requires the Secretary to establish standards for certifying claims and verifying the identity of a family member, and procedures for employers to report fraud. There's also a required public education program in subsection A4 that can be paid for from the contributions and must be done in English and in Spanish.
Mr. Chair, do you want us to hold questions to the end or go?
Well, go ahead. I will say this, that we have to, I don't know what time, you guys have caucus today?
Yes.
Now,
All right, well, I don't know when you guys are going to sacrifice your chicken, but we have to do ours at 2. So we're having caucus at 2. So I'm trying to get through this bill. I mean, if you can hold them to the end, it'd be great, just so we can try and get through the bill, okay?
Yeah.
I don't want you guys, I want you to be as unsurprised as possible.
Yeah, we try to save businesses starting at 1:45 and you guys are killing them at 2. So yeah.
What? Okay. Thank you.
So now we are on page 11, section 8.3-404. This section just lays out the enforcement mechanisms the Secretary can use in general: subpoenas, investigations, any civil actions. It also authorizes the circuit court to compel testimony if a person fails to comply with the subpoena, and it still requires compliance. Even if you plead the 5th, you won't be prosecuted, but you still have to tell what happened, tell the truth.
Mr. Chairman,
Yes.
repeat that, please. That last statement.
So it also, if you go to subsection or subparagraph, I guess if a person fails to comply with the subpoena, that's a complaint. The next one, you can be excused from complying with the subpoena issued under A5 if the testimony required may tend to incriminate the person or subject the person to forfeiture penalty, except as provided in subparagraph 2 of this subparagraph. After claiming the privilege against self-incrimination, a person may not be prosecuted or subjected to any forfeiture or penalty because of any matter, thing, or transaction about which the person is compelled to produce evidence or testify. If the person commits perjury while giving testimony, the person is subject to prosecution for that offense.
Thank you.
Go ahead.
8.3-405 just lays out who can represent the state in a civil action. 8.3-406 requires the Secretary to submit an annual report on September 1st on the administration and operation of this title, regarding the preceding fiscal year and lays out what should be in the report. On page 13, number 7 under B, that is a suggested amendment for the committee, adding to what would be included in the report. So the next section is 8.3-501, just establishes the insurance fund. 8.3-502 just says that requires the secretary to administer the fund, the treasurer to keep the fund separate, and the comptroller to account for the fund. 8.3-503 basically establishes where the money comes from in the fund, and that the money can only be used for this particular title. 8.3-504 and 505, basically they are just a boilerplate that lays out the treasurer's responsibility as custodian and related to paying the benefits. 8.3-506 states that the employee has no right or claim to money paid into the fund. 8.3-601 requires contributions to begin October 1st, 2023. The next sections are part of the suggested amendment. We have stricken subsection B and added a new subsection B, C, D, and E and F, if I believe. And basically by December 1st of each year, the department, DVM, NFIB, the chamber, and a representative of a private sector labor group must do a cost analysis focused on solvency and paying benefits. It also requires MDL, DVM, NFIB, the chamber, and a representative of a private sector labor group to study and make recommendations regarding the total rate of contribution, cost sharing formula within a certain range, the cost efficiency and benefits of doing an RFP for a third-party administrator. It also requires MDL to set the total rate of contribution and the percentages paid by December 1st of each year. It requires the rate of contribution to be applied to all wages up to and including the Social Security wage base. All employees are subject to the same rate and all employers are subject to the same rate. Employers can pay a portion of their employees' rate up to the max contribution rate, and self-employed individuals can participate but must pay the full total contribution rate. So now we're on page 16, 8.3-701. This section provides that claim submissions begin January 1st, 2025. It also requires that if the leave is foreseeable, must notify the employer at least 30 days before the leave. If the leave is not foreseeable, must notify the employer ASAP and comply with the employer's notice and procedural requirements for such leave. And intermittent leave in increments of no less than 4 hours may be taken, but it should be scheduled as to not unduly disrupt employer operations, and the reason for using the intermittent leave must be provided. It also restates the reasons that a person can use the leave.
Mr. Chair,
Yes,
can somebody let Rick in?
I'm in.
Oh, okay.
Thank you.
keep going, please.
So starting on the bottom of page 17, top of page 18 is section 8.3-702. This section limits the claimants to only 12 weeks of leave in a year unless the claimant has to care for a child within the first year of birth or placement, and the claimant has their own serious health condition. The leave must be taken concurrently with FMLA. The claimant also has to exhaust all employer provided leave before receiving benefits under this title. If the claimant is currently receiving unemployment insurance or workers' comp, they are not eligible to receive benefits under this title. And if the claimant is receiving workers' comp for permanent partial disability, they may be eligible to receive benefits under this title. On page 19, section 8.3-703 sets out the calculation for determining the amount of benefit based on the state average weekly wage, and goes through that calculation for the whole calculation formula. So if a covered employee makes less than 65% of the state average weekly wage, they will get 90% of their weekly benefit. If the covered employee makes more than 65% of the state average weekly wage, then they would get 90% of their weekly wage up to 65% of the state average weekly wage, then 50% of the individual's weekly wage that is over that 65% threshold. For an individual taking partially paid leave, the weekly benefit amount is the lesser of the amount required to make up the difference between the wages paid to the individual, while the individual is taking partially paid leave and the full wages normally paid to the individual, or if the individual's average weekly wage is greater than 65% of the state average weekly wage, 90% of the portion of the individual's wage up to that threshold, plus 50% of the portion of the wage above that threshold. The weekly benefit payable to a covered individual ranges from a minimum of $50 to a maximum of $1,000 for the 12-month period beginning January 1st, 2025. Beginning January 1, 2026, the maximum benefit must generally be increased by the annual percentage growth in the Consumer Price Index. This section also specifies that the increase applies only to claims filed after the date the increase becomes effective. An MDL is required to notify the employer of a claim within 5 business days after it's filed, approve or deny the claim, and notify everyone within 10 business days, and make the first payment within 5 business days of the approval, and make payments every 2 weeks until the benefit ends. The Board of Public Works may temporarily suspend an increase in the maximum weekly benefit if the board determines that the seasonally adjusted total employment is negative. They may also consider the performance and state revenues when determining whether to temporarily suspend an increase. If the board suspends, the rate will stay the same for 1 additional year, and the board must notify the secretary, and the Department of Labor must notify employers of an increase. So that all takes us to page 23. Which starts section 8.3-704. If the IRS determines that the benefit payments are federally taxable, the Department of Labor must provide notification for claimants. A covered individual may elect to have federal income taxes withheld, and the Department of Labor must do so at the rate specified in the IRS code. These withholdings must be held in the fund until it's transferred to the IRS as payment for income taxes. Also on page 23, 8.3-705, which provides an employer may satisfy the requirements of the bill through a private employer plan consisting of the employer provided benefits, insurance, or a combination of both, if the plan is offered to all eligible employees and at least meets the rights, protection, and benefits provided to a covered employee. A private employer plan must be filed with the Department of Labor for approval. An employer that provides covered employees with a private employer plan and those covered employees are then exempt from the bill's required contributions. Page 24, 8.3-76. Additionally, the employer generally must restore the individual to an equivalent position of employment. And generally, an employer may only terminate an employee on leave for cause and may only deny restoration of a covered individual's position under specified circumstances. This section does not apply to an employer with developmental disabilities who self-direct services under the Maryland Medicaid Home and Community-Based Waiver Program. The next section is 8.3-707, which starts on page 24 and goes to page 25. If a covered individual is receiving benefits or is taking leave, the employer must continue any employment health benefits in the same manner as required under the Maintenance of Health Benefits in the federal FMLA for the time that the covered individual is absent from work or receiving benefits under this title. 8.3-801, also on page 25, an employer must provide written notice to each employee of the employee's rights and duties under the bill at the time of hire and every year thereafter. When an employee requests leave under the bill or when an employer knows that an employee's leave may be for reasons under the bill, the employer must notify the employee of their eligibility to take leave with benefits, for which benefits may be paid within 5 business days. The notices required under the bill must be provided in accordance with regulations adopted by the Secretary. On page 26, section 8.3-901, an individual is disqualified from receiving benefits for 1 year if the individual willfully makes a false statement or misrepresentation following a material fact or willfully fails to report a material fact to obtain benefits. An employer is subject to a civil penalty of up to $1,000 for each occurrence if the employer willfully makes or causes to be made a false statement or willfully fails to report a material fact regarding an employee's claim for benefits. An employer may not willfully fail or refuse to contribute to the fund or take deductions from the employee's wages to pay the employer's contribution. 8.3-902, the Department of Labor may seek repayment of benefits from an individual who received benefits in error or as a result of willful misrepresentation, or if a claim for benefits is rejected after the benefits were paid. The Secretary may waive the repayment of benefits if the error was not due to a false statement or misrepresentation, or if the repayment would be against equity and good conscience or administrative efficiency. The next section is 8.3-903 on page 27. If an employer fails to pay contributions, the Secretary may assess the amount of contributions and interest due, make an additional assessment of up to 2 times the contributions withheld as a penalty, and order an audit of the employer for the immediately following fiscal year to investigate and determine compliance with the bill and other labor laws. 8.3-904. A person may not discharge, demote, discriminate, or take adverse action against a covered individual for filing, applying for, or receiving benefits and other reasons as specified in this bill. 8.3-905. If an employee believes that an employer has violated the bill, the employee may file a written complaint with the Secretary. The bill specifies how the Secretary must investigate and enforce the bill, which includes mediation, issuing orders, assessing a civil penalty of up to $1,000 for each employee for whom the employer is not in compliance, and asking the agent to bring an action on behalf of the employee. Within 3 years after the date of an order, an employee may bring a civil action to enforce an order. If an employee prevails in an action, the bill specifies what the court may award.
Erica, on that, briefly, on that, to be clear, but that's just the private right of action only exists after an order has been issued by the Secretary, correct?
Yep.
This isn't just a random private right of action with us in 6 years. It's only for the enforcement of an order, correct?
Yes.
Thank you.
The next section is 8.3-906, which starts on page 30. And in that section, the Secretary must establish a system for appeals by covered individuals who are denied benefits and may use the system. There's a system currently in unemployment insurance, and the Secretary can use that system. All administrative remedies must be exhausted prior to judicial review, and procedures must be in place to protect confidentiality. 8.3-101 simply just states the short title that is cited as the Maryland Family and Medical Leave Insurance Program. The next part is the state finance and procurement article, which it just establishes the fund and where the fund is. The special section number 2 makes the act prospective. Special section number 3, all of these are on page 31, requires a report by the Department of Labor on whether covered employees can also receive unemployment insurance and the impact of dual eligibility has on an employer's rating. Special section number 4, which we've also amended, requires an actuarial study and report and recommendations on the cost to the state for paying the employer contributions for specified community providers. And special section number 5 states the intent that the state pay the employer contribution for community providers that are community-based agencies or programs funded by the Behavioral Health Administration, Developmental Disabilities Administration, or the medical care programs. And that section is effective January 1st, 2023. Special section number 6 on page 32 states the intent that the state pay the employee contribution for those making less than $15 an hour. And this section is also effective January 1st, 2023. Special section 7, the state will only pay the employee contribution for those making less than $15 an hour until June 30th, 2026. Special section number 8, the Department of Labor must adopt regulations by June 1st, 2023. Special section 9 just lays out all of the effective dates I read in the previous special sections. And special section 10 is the final effective date, and the act will take effect next June 1st, 2022.
Okay, that's the bill in a nutshell. We do have a few more minutes, so Delegate Watson.
Thank you, Mr. Chair. I mean, that was a lot of information, a little bit of time, so I just want to ask a couple quick questions. Number one, there is an instance where someone can take 2 leaves in 1 year, is that correct?
Yes.
And what section of the law is that in, and what's the parameter there?
So the parameter there is if you have newborn care, so a new child care has been placed, you've either given birth, become a parent via foster care or adoption, you can take 12 weeks for that. And if you've had your own serious health condition.
Okay. What section of the law is that in?
8.3-702.
Thank you.
Okay. On self-employed individuals, you say there's a requirement that they sign up for 3 years. Is that correct?
Correct.
Yes, that's the initial.
Is there a waiting period, or is that 3 years because they're worried about adverse selection, or what was the thinking behind that?
Thinking behind that is 3 years because you have to pay in for 3 years. Like myself, I own a business. So what would stop me after a year from saying, hey, I'm sick, I'm not working? Basically, because they're solo, they're paying both sides. They would have to wait 3 years because they're going to be pretty much self-verifying all this information.
Okay, wait, let me just make sure I understand. Are you saying they cannot make a claim for 3 years?
Correct. They have to contribute for 3 years before they can make a claim.
Is that the same for everyone else?
No. 1
Okay,
year.
so why is that the criteria for self-employed again? And I'm trying to understand why that is for self-employed. Can you?
No, because as we're talking it out, I'm seeing what you're saying, because it's going to be validated by the state either way. Every claim is validated by the state, not the employer. So your point is, why are we treating them unfair? Why are we treating them differently?
So,
The
sir,
only-
can
Go
I
ahead,
jump
counsel.
in, sir?
Go
Yeah.
ahead, counsel.
So actually, the way it's written in the bill is that they can participate for an initial 3-year period. So if they choose to come in, they have to stay in for 3 years.
Oh, so that they can start collecting after a year like everyone else.
Yes, they have to stay
Outstanding.
in the program for 3
Outstanding.
years.
Okay,
And then
I don't know how you would enforce that, but
Well, and you're correct on that, but the whole point is you're trying to get some predictability in the fund.
right. Yeah, I still think though you're treating them differently than other employees, but we can talk about that later. I want to keep moving. The only other thing I want to ask right now is anywhere in this study, do we tackle whether any kind of study or about whether or not the Department of Labor can actually handle this program?
No, there's nothing in the study that looks at specifically whether or not the Department of Labor can tackle the program, but there is the provision that looks at whether or not they should do an RFP for a third-party administrator.
Okay, I cede the floor. Thank you.
Thank you. Delegate Valderrama.
Thank you, Mr. Chair. Actually, yeah, again, just a couple quick questions, and I'll probably talk to you guys offline because I have many. But Delegate Watson just said steady, but it's looking at this bill. This is no longer the commission. This is okay. And then also on 8.3-403, where it mentions those who will be, I guess it's the composition of who will be.
Correct. You're muted yourself, Chris.
Sorry, I still see that there's no one from the actual providers. Like I see there's a private sector. There's a lot of business, which I have no problem business being involved here, but they're not the ones providing. So could we not include someone from that community?
Who would you consider a provider?
Well, I can find many different organizations. So I just wanted to mention that.
I don't understand what you mean by provider. Provider of what?
Well, like, so for instance, whoever is providing the care, like for instance, if I was providing care to whomever, I'm just saying, I feel like there's so much business folks in here, but not enough of the private sector. Like we have a public union, that's great. I can go back to that.
What provider would, I don't understand, like a healthcare provider? They
Yes,
would play
but-
no part in, but they would play no part in this beyond the employer side of being a healthcare provider.
Well, I can always come back to that. But the next part would be on I'm jumping around, but is the 8.3 section 705, was that an Aflac reference?
I believe so.
Okay, and it said some, Erica, you mentioned an exemption. for that?
705, I apologize. No, that's not an Aflac reference.
Okay, what is that reference?
That's just saying that they have their own private benefit plan that because you can use You can use anything. If they have a plan that it's better, that it's equal to this or exceeds what we're asking to provide, then they don't have to participate in the program.
Okay, gotcha. And then the last one, I have several, but I'll have that later. As far as the foreseeable, there was a language about how quickly, if one knew one was going to be ill.
So if it's foreseeable, you have to notify them within 30 days of taking the leave. If it's not foreseeable, as soon as possible.
Correct.
So just, all right. Oh, and just to reflect on what I was mentioning earlier, Mr. Chairman, about like caregivers.
Yeah, but I don't understand, except for them being employers, what would the purpose of, I would think that would be the opposite, because caregivers would be employers. That would still be stacking it towards the businesses because they're employers.
Well, they are employers, but they are in the industry of caregiving. Whereas, for instance, who's the last one? I can't remember their exact name, but the one Delegate Chi suggested be added on. Like, they're not caregivers. Like, I'm not saying none of them in that
But
association.
this isn't a caregiving bill. This is an insurance fund. The whole point of this is to create a fund. Having doctors on this would be pointless because their medical expertise would have nothing to do with the way we're setting up the regulations to promulgating regulations for the fund.
Okay,
This is a fund, an insurance fund, and how it's to be managed.
That I get. No, I understand that we don't disagree on that, but I guess we'll agree to disagree that I feel caregivers should be included. But okay, thank you. I appreciate it. I have other questions. I'll just take them offline.
Delegate Pippi.
Thank you, Mr. Chairman. I don't know if I couldn't find it. Where do we define serious health?
So serious health is in the definitions section. Give me.
Just tell me that it's in there, right?
It is absolutely defined. Give me a second. On page 5, at the bottom of page 5, starting in line 30.
Says, okay, defined in paragraph 1 of this subsection.
No, it says
No.
secretary means, you look on page 21, it says serious health condition means, and it goes through the different definitions of what it is. On page 5, line 21. Do you see it?
Yes, sorry, line 21 is where
Yeah.
it starts.
Illness and injury and impairment. Okay,
You have to keep reading because it also says.
patient care hospice. All right, good. That's good.
Mhm.
And then how did we come to the 3 years to bring a claim for someone who's actually awarded?
Statute of
eligible?
limitations there, brother.
Huh?
That's the normal statute of limitations in Maryland for most everything.
All right, and then reasonable notice to employer as soon as possible. Has there been any discussion about cleaning that up, or is that standard language?
Well, it's 30 days if it's predictable, as soon as possible, like if you don't know. Like,
Sure,
so,
like an emergency room.
correct.
All right, that's what I got.
Thank you, bud. Delegate Charkoudian.
Thank you, Mr. Chair. Let me just first thank you, Mr. Chair, and the staff and everyone who worked really hard on this. I know that you've been doing a lot of work. I had, I think, clarifying questions. The first is I'm trying to figure out what happened to the employer of people with 15 individuals or less. I know, because I was tracking what you had in your bill, Mr. Chair, earlier. And is this parallel to your bill, or does this mean if I work for a small employer, I don't get leave?
You can do it, but the employer is not required to participate with you. You still have every employee in the state has the right to participate.
So if
But-
I work for an employer with 15 people or less, then I would have to pay 100%? Is that?
That's correct. The
Okay.
employer does not have to participate.
But would the employer, I'm sorry, so would the employer have to keep my job if I paid in, took the leave, or they wouldn't have to?
I think as the bill is drafted, they are not included in that.
Right. So they wouldn't have to, right.
So small employers could choose,
Correct.
but the employee couldn't choose. It's the employer who would be choosing in or out.
The employee could choose to participate in the program
But they could lose their job if they take the 12 weeks.
as the bill's written.
Okay. My next question is also trying to understand the section about using your leave before you use this leave. So I'm just trying to think through what that looks like. So if you have a child and you are taking, 3 months, 12 weeks. But you may still need, if your child gets sick, you have to take them to the pediatrician, right? You've got a baby, they get sick a lot, or shots, whatever. So does this mean you have like nothing left then after that? What is that? What is this section about using all your leave? Is it not possible to use to end this with then some leave left?
Well, the way it was written was that you would take your family, your sick leave, things of that nature, and then you could this would add to that. It's just you take your sick leave first. If your child was sick as of now, you would take your leave. This just affords you an additional 12 weeks on top of your leave, but you must exhaust your leave first.
So, okay, so if I am having a baby, I exhaust my leave, I take this now and I come back to work, and then 2 weeks from now, my child gets sick, I have nothing left? Is that correct?
You're saying if you take all your leave and then you take the 12 weeks,
Yeah.
then you have, yes, but that's what the same question would be the same if you took all your leave now.
Okay, but I could,
get sick.
but if I take all my leave and then I take 10 weeks, then I could
Still have
still
2
have-
weeks.
2 weeks left.
I would have 2 weeks left that I could use if my child gets sick.
Depending on,
Yes.
if he fits within the guidelines of the serious health condition, yes.
Okay. Okay, and then the last question, I know this wasn't I think this is how it came over, but on page 24 of 32, is 8.3-706. I'm trying to understand what this means. So an employer who is a individual with developmental disability self-directs, can you explain that to me?
Please, God, I'm listening.
Oh, that is exactly how it came over from the Senate, and I am not sure as to what discussions they had across the street and added.
And I will make sure,
Okay.
Delegate Charcuti, that's one of the things I've highlighted. I remember something like this in the last family leave or working families bill we did, but we'll get to the bottom of this. Again, obviously we'll have till tomorrow because I do have some concerns with that as well. That is how it came over.
Okay, I just don't quite understand it. So I appreciate that, Mr. Chair. Thank you.
Yeah. Thank you. Pippi, you're done, correct? Delegate Ernst?
Thank you. A quick thing, this 100% we're talking about 75-25, where do we come up with what 100% is?
As far
The
as
rate,
the actual number?
correct.
So it's not, that is part of what we amended out. That would be part of the study.
If you look on page 15, they break down, the contributions and when they do the study, what they're going to figure out the total rate of contributions, the cost sharing, the cost efficiency of RFP, things of that nature. But it's based on the Social Security wage cap, which is 147,000.
Okay, so not that this would ever be abused, but if I had 50 employees and I maxed this out, everybody took their 12 weeks, how would that affect my rates?
Your rates don't change at all. It has nothing to do with your rates.
So it can be abused, it can be used for all the way through, and there will never be a rate change, or will that be
It won't be a rate
universal
change, period. The rate change it's tied to CPI.
Okay,
So
but usage would obviously depend on this, wouldn't it? How many benefits?
sorry?
The use would obviously,
In every state we've looked at, it's no more than 5% of total participants.
okay. Now, the other part was if I am paying child support and all that stuff, will that still come out of these benefits or will that be different?
child support would be a separate court order
Yeah, that's
payment
something
that you would be
different.
giving to.
It wouldn't be, this would not have any effect on, I could get away from paying child support by utilizing this?
Not at all.
Okay. That's all for now. Thanks.
Thank you, Lily. Delegate Chi, apologize.
That's okay. Thank you, Mr. Chair. A quick question about page 9, 8.3.43, about the Secretary of Labor in consultation with the DBM and business community and labor community. I want to echo the concern I raised in the last work session in the hearing about this, which is the nonprofit community. I continue to be concerned because the state is required to pay.
And Lily, I'll address that. We actually are going to, Erica, we're going to do a chair amendment on that too, and not specify, but require a report on who they are meeting with. And it's obviously causing some issues either way we do it. If we tell them exactly who to meet, that they'll only meet with those. the worry is obviously if we don't ask them to meet, but we're going to give them examples, obviously through the chair and obviously through the speaker of who we expect them to be working in consultation with. So we might
Okay,
take down the narrowed down language and just say business and nonprofit groups. And
Okay.
then, and then actually, send what our expectations are.
okay, that sounds good. And also I want to bring back my original amendment, which was based on your bill and the Delegate Valderrama's bill, which is to carve out the family farms from this legislation. Thank you.
Oh, okay. Thank you.
Yeah,
Are you going to do an amendment tomorrow?
probably later today or tomorrow, yeah.
Yeah. Just, we're going to vote on this between sessions. So
Thank
Johnny
you.
Mouts.
Okay.
Thanks, Chairman. Real quick, Erica, so just to go over this one more time, the way the bill's drafted, if you apply for a benefit, you receive a benefit, are you prohibited from receiving other benefits, or are you still allowed to receive other benefits?
It depends on what other benefits you're referencing.
Okay. Is there a section, I saw in the bill where it says concurrent, that means that you can receive both benefits at the same time, correct?
So you're talking, that's all my question. What benefits are you specifically
Well,
referencing? Like
there's-
FMLA or so you would have to take it concurrently with FMLA. But if your employer, if you have, leave benefits through your employer, you have to exhaust those first, and then you can take the benefits under the act.
Okay. And then, so the bill, the way it's drafted, the state picks up the share of the employers for all the employees that make under $15 an hour. That's correct, right? That's in the,
Correct.
right. And
That is
then,
intent language that's included in the special sections at the end, one of the special.
I just want to make sure that it's still in the bill, and the state also picks up the employer's share for developmental disabilities. And what's the list of them that are covered by the bill?
Behavioral Health Administration, community-based agencies or programs funded by Behavioral Health Administration, the Developmental Disabilities Administration, or the medical care programs.
Thank you. You answered my questions.
Thank you, Delegate Brooks.
Thanks, Chair. Erica, under section 8.3-201, line 11, on page 3, line 11, it says employer means a person or governmental entity, 15 individuals in the state. Is there an expanded definition of employer?
I'm sure there's one in the labor and employment article. And generally, I think the last definition I looked at, I don't remember the exact section where it was in labor and employment, but it defines an employer as anyone who employs at least one person.
Oh, okay. And secondly, Mr. Chair, if I may, now would a person who files for this, take advantage of this, would that person be allowed to file for unemployment insurance? Any other type of compensation?
No, you can't take advantage of unemployment insurance or workers' comp.
Okay. And lastly, the FMLA, that's the federal medical leave. Now that grants up to 12 weeks of time away for several different type of
unpaid leave to companies that employ 50 or more people.
50 or more people, right. So what, I guess that this is sort of piggybacking on what the previous delegate asked. So they would not be able to take advantage of both at any one time, is what we're saying?
They would have to be taken concurrently. So no, they could not take advantage of one and then take advantage of the other. They would have to be taken at the same time.
Oh, I see. Okay. All right. Thanks, Chair.
Delegate Adams.
Thank you, Mr. Chair. All right, so the federal leave currently in law unpaid, what is the employee cut for that? Is it 15 or 50?
It's 50.
50.
50. Okay, so and is this bill mirroring or copying the requirements of the federal leave?
No.
It's different.
Yeah.
So are we adding on top of the unpaid federal leave with this Maryland paid leave?
But you can't take them, they have to be done concurrently.
Well, no, separately. What I'm saying is if they're not the same thing, can you take federal leave unpaid and then, or vice versa, take all the Maryland leave for the multiple weeks that you can take off and then take unpaid leave for an additional period of time because there are two separate forms of leave?
The bill specifically says concurrently.
Concurrently. They have to be done concurrently.
Okay. So let's say Johnny Mouts is working for me. His son gets a compound leg fracture. He's in the hospital for 4 days in care. How long under the bill could Johnny Mouts take paid leave, assuming he's exhausted all the sick and safe leave and all that? How much time could he theoretically take as his son's recovering under the bill?
If it's for his son's recovery under the bill, he could take up to 12 weeks of leave if it comes up under the definition of a serious health condition.
Well, I think so a compound fracture of a leg is a serious injury for a child. So 12 weeks. So there's no consideration for the fact that the young man probably gets a cast, probably gets able to go back to school, et cetera, et cetera.
No, sir. It actually defines serious health condition. In addition, it has to be inpatient care in the hospital, hospice or residential healthcare facility, continued treatment by a licensed healthcare provider, continued treatment by or supervision at home by a licensed healthcare provider or a competent individual under supervision of a licensed healthcare provider. So a compound fracture would not be, while he's in, of course, but once he's out, it would not be considered a serious health condition unless he has some infection or something that he's consistently being monitored by a healthcare provider.
Okay, so the exercise that I'm trying to go through here, Chairman, is me as an employer, how am I able to figure out?
You're not.
How long?
You're not. They apply to the state.
So it's on their good word, and
it's the state. They apply to the state, and they have to show verification and certification as to what the issue is before the state approves the claim. And again, this is a claim. And then once they approve the claim, they have to notify within 5 days the employer that the claim has been approved.
All right, last question, because there's a problem there.
What's the
last
problem?
question?
Just curious.
It's a big problem because if you're an employee who's taking off 12 weeks and you're having the state determine whether or not they should be able to take the full 12 weeks, what's the employer doing in the middle? The last question I have is with an employee who's working in this environment, I have to find a replacement employee. Correct. And let's just say that this replacement employee is great, better than even maybe the person who is taking the leave. And all of a sudden, here comes Johnny Mouts. It's time for him to come back to work. Is the state going to protect me against any complaints in court if I have to lay that person off? Obviously, the person has a right to do whatever they would or wouldn't do in a court of law. But maybe they get mad. Maybe they did a great job. Maybe I gave them a performance evaluation. But I don't have room for Johnny and the other person I hired to replace Johnny. Is the state going to hold me harmless in that scenario?
As a fellow employer, it would be my hope that you would hire this person temporarily, as I've had to do, because one of my paralegals is pregnant. So the person I hired to replace them, it's notified they're on a temporary basis. And you're correct. They can find a nice grimy lawyer to sue me, but I do have it in writing that this was a temporary hire.
Well, of course, you're not going to find somebody to work for Johnny Mouts because he's too good at the job. And you got to find a qualified employee who can replace him for that 12 weeks. So no, nobody's going to come to work for me just as a gig, since we like the word gig around here, for 12 weeks and then be left. The problem, and I think we need to reinforce this issue, is that once I hire somebody in that scenario, they are afforded every right under law as it relates to me as an employer. And I'm saying that I would like to make sure that the state holds me harmless if I have to replace Johnny Mouts for 12 weeks, and then I have to lay that person off and they get mad and then sue me.
So okay. Delegate Adams, just to your point on page 24, okay. Starting at line 15, it lays out, it says an employer may, during a period of leave from work, which benefits may be paid under this title, they may terminate employment of the covered individual taking the leave only for cause. So without knowing the reason why you might want to let employee Mouts go, there is a provision in there for termination for cause. There's also a provision in there for denying restoration for certain reasons, for specified reasons.
Erica, I think
what you just said is what I'm worried about.
Yeah, his point
because I would be laying this person off for no cause. They're great.
Right. It's the new person. It's the new person that comes in and is now an employee. And his argument is they have all the rights of an employee now. Even though I would argue you hire them contractually and temporarily, that's just me. But if he does decide to hire them full-time as an employee because he's doing a bad job with managing his company, then they will indeed have all the rights of an employee at that time. And again, as long as you terminate them, you don't have to say why. Unfortunately, that is the bad cost of doing business. You're correct. But that would happen if you had a pregnant employee now and she took 6 weeks off.
All right. Well, Mr. Chairman, I could spend 2 hours going through scenarios where this bill is not workable. That's just one of them.
Well, I appreciate that. I'm sure you'll have some amendments for me, brother, but I know we got to get ready to jump off. I appreciate everybody's patience. I just tried to get this in your lap today so we could vote it tomorrow. Please, I'm sure I'll be hearing from you guys soon. Thank you very much. Contact Erica with any amendments.